Hello, welcome. You're watching Lost in Law. My name is Tim. Let's go look at some interesting cases. Today, we're going to be looking at the shooting of Sammy Yatim, Yatim, I don't know. And of course, the subsequent trial of Officer Fursillo. Now, we're not going to go too deep into this. This is going to be a quick thing, but the weird quirk of this case was that the officer was convicted of attempted murder for a shooting that occurred after he was acquitted of second-degree murder of the same person. Now, the way I just explained that may seem a little confusing to you, and I promise it'll make sense once we go through it. But you got to be asking yourself, how can you attempted murder someone after you murder them? Remember, the murder has occurred. Mr. Yatim is dead. He was acquitted of the second-degree murder, but found guilty of the attempted murder after the murder of which he was acquitted for occurred. So let's have a look. We're going to first watch the video. And I'm only going to show a few seconds of the video that's relevant here because there's, as you can see, there's a bit more to it. I'm just going to show this quick disclaimer. You know, there is a police shooting that occurs, but the intent here is to provide education from a legal context. We need, in order to understand how we get to this conclusion, we need to see what happened. So I'm going to show the video. I'm going to just do a little bit of, there's no sound, so I'm going to do a little bit of commentary of what's going on, and then we'll go look at the law. So Mr. Yatim is shown here at the front, holding a knife, and this is Officer Fursillo back here. So you can see that Mr. Yatim backs into the streetcar. You can see that Mr. Yatim backs into the streetcar. He then advances and is shot. Then you'll see the muzzle flash here a second time. A second volley of shots is made. Now you can see some movement here, but as we're going to look, the facts of this case are quite telling. So yes, this is Officer Fursillo here. We'll get that off the screen. And we're going to go into his trial. So this is, of course, the Officer Fursillo being charged with a crime. So, of course, you know, it's RV Fursillo. If you're watching this channel not for the first time, you'll know that in Canada, everything is stylized as RV, the accused. So this case, 2016, there's a lot of other stuff covered in this case regarding a charter challenge to the mandatory minimum sentence. We're not going to go into that because I haven't covered that stuff in my charter class yet. But we certainly want to start here at line 3. So we'll go through kind of what we just saw in the video. So, of course, oh, and by the way, we, you know, our police officers, the rank that we use includes constable. We don't have deputies in Canada. We use the English style of police ranking. Same with our military, too. Like, we have, I think, yeah, I'm not entirely sure about that one. I'm not part of the military here, but anyways. So the officer was on duty, responding to an emergency call when he shot and killed Sammy Yatim, who was brandishing a knife aboard a Toronto Transit Commission streetcar. Is it commission or whatever? The Special Investigations Unit, which sounds like a TV show. Dun, dun, dun. You know, the Special Investigations Unit, which is the oversight body that investigates all police interactions of a serious nature. So that's, you know, someone suffers a serious injury, someone is killed, or there's an allegation of sexual misconduct. So this is automatically triggered by the fact that it was a shooting death of a civilian. So in August 2013, so you'll see, right, July 2013 is when the incident occurred. August 2013, they laid the charge of second-degree murder. So you have to understand that when police shoot people, they have to have the legal justification to do so. If they don't have the legal justification, then they have committed a crime and you charge them with the crime as if they were a civilian. They lose the protection of being a police officer. So, that, of course, is pursuant to our Canadian Criminal Code, which we've covered to death and will continue to cover to death because it is an absurdly long document, and there's just there's no way of making it shorter. In any case, about a year later, so we're now in July 2014, the Crown added a second count of attempted murder because of evidence arising from a preliminary inquiry. Now, the preliminary inquiry is an optional step in Canada, but in these serious cases where there's allegation of a murder, right? Second degree murder is his charge, and then of course, you remember from my my first video, if you commit a culpable homicide, it can be a murder or manslaughter, and then there's certain elements you need to meet in order to call it a murder. We'll go into those in just a second, but there's also defenses to murders and attempted murder, for that matter. So let's continue looking at the facts of the case, and we'll get into the code in just a second. So during the course of the encounter, which lasted 50 seconds, the officer fired a volley of 3 shots, which, based on the medical evidence, caused the death. The first volley of shots was the subject of the second-degree murder charge. As a result of the first volley, Mr. Yadam fell on his back onto the floor of the streetcar. The officer assessed the situation for approximately 6 seconds and then fired a further 6 rounds, which caused serious injuries to the lower body region. The second volley of shots was the basis for the account of attempted murder. Now, the medical evidence here, we're going to go through it, but we're going to take it at face value. We're just going to assume, because trials in Canada are not public by default. I'm not entirely sure of the rules around the access of press into high-profile trials, but I do know that you're not supposed to record them. So in Canada, we only ever get the courtroom sketches. And of course, the only way to learn to listen to the testimony is to be at the trial. So we're not going to spend too much time on the medical evidence here. We're just going to read it as fact and take it at face value. But the evidence indicated that given the mortal wounds of the first volley, from the first volley, the wounds from the second volley did not contribute to the death or accelerate the death. So this is going to be key here. The second volley of shots had no bearing on the outcome of the encounter. The first shots are what killed him. And in fact, it'll say, it'll say exactly how that happened. The evidence of the witnesses was that Mr. Yadam was still alive during the second volley of shots, and you could see that based on the movement of his feet. However, the medical evidence indicated that he had been paralyzed from one of the shots of the first volley and did not feel the impact of the shots of the second volley. Also, the medical evidence indicated that Mr. Yadam was in the process of dying when the second volley occurred, as one of the shots from the first volley had ruptured his heart, and he expired within minutes of the volley of second shots. Okay. Again, the medical evidence, we're just going to take it at face value. The first volley of shots, he got hit in the heart, and he's in the process of dying and would have died regardless of anything else that had happened. There was no medical intervention that maybe if he was shot on the surgeon table at the most advanced equipped, level 1 trauma center hospital, hey, maybe they could save him, but not in this circumstance. There was no way to foresee of him being alive after taking a heart shot. However, he's not dead when the second volley of shots occurs. And you'll notice in the video, there was quite a pause in between 2 volleys of shots. Now you can go back and watch the video yourself. You can slow it down. I think there are other angles you can look up. This was it'll be under that name, the shooting of Sammy Yadam. But I didn't want to spend too much time looking at that because we're not here to talk about the nature of policing or, the whole defund the police movement, which, this incident really set off those kind of protests up here north of the border. But these things just don't tend to stick around very long. And the uniqueness of this case is just how you can get to a sort of like a head scratching outcome. But then when you read the words of the law and you realize, oh, okay, that's how we got there. So that's basically what we're looking at here. Forcillo testified on this in his own defense that he relied on the defenses provided by sections 25 and 34. So in January 2016, a jury acquitted Officer Forcillo of second-degree murder, which was related to those first volley of shots. So these defenses, and again, same as the U.S., the jury will not return innocent as a verdict. They will return guilty or not guilty, or not guilty by reason of not criminally responsible, NCR. But that's not applicable here. They were going to return guilty or not guilty. So the Crown has to establish, based on the standard of beyond all reasonable doubt, that Forcillo committed second-degree murder and did not have a defense as provided by these sections. Like I said, we'll look at those in just a second. But they convicted the officer of attempted murder charged in count 2, which was the subject of the second volley of shots. Okay, now let's have a quick look. We're going to have a look at Section 25, which is, of course, the protection afforded to police officers. Now, the language here is very, official and fancy and stuff, but just basically put, you're a peace officer and you are required or authorized by law to do anything in the administration or enforcement of law. You are justified in using as much force as necessary for that purpose. Yeah. So a lot of other channels have broken down, okay, what is an imminent threat? Which is, that is the self-defense in section 34 of our criminal code. So, these are not criminal code. Yeah, sorry, yeah, they are criminal code. Never mind. Yeah, so section 34 here allows for self-defense of a private citizen. So, contrary to popular belief on YouTube, we actually do have a right of self-defense here in Canada. The standard, however, is quite high. The circumstances need to be quite exceptional to justify using deadly force. And of course, that's all laid out here in, the factors. And actually, we do have defense of property provisions, but again, they're very narrow. They're not as well established as, say, Texas or Florida, where you have stand your ground provisions. Anyways, none of those apply in this case. The defensive use or threat of force, which of course is a person holding a knife, refusing to drop it, and making some sort of movement or motion to advance upon you. That would qualify as a threat of an imminent threat of force. So, yeah, a police officer has justification to shoot in that circumstance. And that is what the jury found. That based on the evidence and the video evidence presented, there was an imminent threat, and the officer acted within his legal authority in stopping that threat. Therefore, he was acquitted of second-degree murder. The problem we got to in that video is that lengthy pause and the second volley of shots. Now, These defenses are out the window. A person who's been shot in the spine, and yes, I know the officer did not know he was shot in the spine, but as a matter of practicality, it is impossible to be an imminent threat if you've been shot in the spine and you have no means of traveling to where other people are located, right? Mr. Yadin was not holding a hostage. There was no one within his arm's reach, or even crawling distance, right? And simply saying that, well, what if he was to get up and then charge again? But that's not the standard of imminent threat. That is a potential threat. And so police are trained to treat potential and imminent threats differently, right? They're held to a higher standard than the general public. So, Mr. Yadam is on the ground and unable to move. So any evidence, any testimony that says, well, the guy was trying to get up and charge us again, would not be believable based on the medical evidence. And yes, of course, the officer did try to say, well, the guy was trying to sit back up. He raised his upper torso to a 45-degree angle. But the video evidence and the medical evidence would clearly refute that assertion. And so, of course, the jury found you have lost your justification. There is no more imminent threat. So none of these defenses apply. All right. We're going to have a look at attempted murder. So that's Section 239 of the Canadian Criminal Code. And it's every person who attempts by any means to commit murder is guilty of an indictable offense and liable. This stuff here is about the mandatory minimum sentences for firearms, and of course the subsequent offenses. So none of those apply here. We're not going to spend any time on them. But I mean, it's pretty straightforward, right? Attempt means that you had the intent of murder, but you were unsuccessful. So here we are up at Section 229, culpable homicide is murder, right? We just come from attempted murder, which is you tried and failed to commit murder, but you actually did the action, right? You went through with the underlying unlawful act. So of course we go up and, culpable homicide. What is a culpable homicide? Well, it is when directly or indirectly, by any means, you caused the death of a human being through an unlawful act, right? Because non-culpable homicide is not a crime, right? Not your fault. So culpable homicide, a death that is your fault, you committed by means of an unlawful act. So, of course, an assault with a deadly weapon, by criminal negligence, which is, and then these other two, which are not very common. But clearly we're here. It was an unlawful act. You got to remember that when a police officer shoots someone, they have committed an unlawful act, but they have justification to do so here. So we're still under this, section, where are we? We're section 222, sub 5, sub A. We're still here. We've committed the unlawful act. And Frisil does not deny that he committed the unlawful act. He says, yeah, I shot the guy. And there's a lot of video evidence that shows that he shot the guy. Right? So that's pretty easy to prove. But now that we've established that he doesn't have the defense anymore, he doesn't have these defenses because the force was not reasonable for the threat that was presented. Right? So now we're looking at this. So murder is something that causes bodily harm or that is likely to cause death. Again, let's go back to, so we're, come back down to section 229. Murder is when you cause the death and you mean to do so, or you mean to cause bodily harm that is likely to cause death. And that includes shooting someone center mass, as police officers are trained to do, and which, of course, happened here, right? Where the bullet eventually hits them is immaterial because gunshots, typically speaking, cause bodily harm that is likely to cause death. So We're not going to be able to weasel our way out of this definition here by saying, well, what if we shot him in the foot? No, a shot anywhere on the body can cause death. Now, if you want to go argue likely for foot shots, be my guest, but that's not what we're dealing with here. He aimed for and hit center mass. And those kind of shots are likely to cause death. So, we have established these elements. We know that we had a murder with the first volley of shots. Now, of course, he was acquitted because of his defense. But what about the second volley of shots where he loses the defense? He no longer has the protection of the defense. And a couple of things are working here. The intent to shoot was the intention behind the shot was to stop a deadly threat. Your mistake of belief is material here. Now, Fusillo testified that he saw the victim raise his torso up as if he was trying to stand back up. However, the video, the angle of which we did not see, there is another angle which shows the body, but I don't want to show that on YouTube. And the medical evidence, which said that it is literally impossible for him to have done that action, refutes that. So he's trying to argue that he had the mistaken belief, which of course would absolve you of the murder. And therefore absolve you of the attempted murder too. So the evidence refutes that. The mistaken belief is off the table. So now we're back at what was the purpose of pulling the trigger. It was an intent to kill. So you have formed the intent to kill. However, you don't know that the first shot ruptured his heart and was going to kill him. So now you have another mistaken belief. You believe that the guy is still alive and not dying, and you shoot him again. So you've formed the intent to commit a murder. The fact that the first shot kills him is just unlucky on his part or lucky on your part or whatever. Right? Describe it how you will, but the shots ultimately do not kill him. However, the medical evidence was that he was still alive when he was hit with those shots. So what you have done is unsuccessfully murdered someone. But since you had the intent, since you made the conscious decision to pull the trigger, you meet the test for attempted murder. And that is ultimately what Officer Fusillo was convicted of. So if I were to construct the timeline of events, right? Yadam advances towards the officers. We saw this in a video, and I'm not going to play the video again. Just, you can pull it up and run it yourself besides commentary, or just, go back to the first part of the video where I showed it. But Yadam advances on the officers. The officers used deadly force and were found to have been justified in doing so. But the threat has been stopped. And Fusillo stops shooting, reassesses the threat, and reassesses it incorrectly. And then shoots again. So, you have a justified murder in the first volley of shots, but an unjustified attempted murder in the second volley of shots. And that is how you can get convicted of attempted murder on someone of which you had just committed a murder on and were found not guilty. I hope this was an interesting case to cover. I hope that this made you scratch your head a little bit and go, man, the quirks of the law. You can get to some interesting conclusions and places when you deal with the quirks of the law. But in the end, I think the judge sentenced the officer to 6 years in prison. So I do believe he's out right now. And of course, in Canada, we have that 2/3 rule, right? You can get out on good behavior if you serve 2/3 of your sentence. You can also, if you've completed 1/3 of your sentence, you can apply for parole, which is different than early release. But again, we haven't covered that stuff in law school. These are just things that I know from the common man understanding of the nature of getting sentenced here in Canada. But I hope you found this interesting. Next week, I'm going to be covering a couple of introductory concepts around contract law that I have found quite interesting. I think would be interesting for the average person to know. Of course, contracts, the funniest joke in lawyering is, oh, have we formed a contract? And you'll understand that there are a lot of things that you form contracts around, but there are a lot of things you don't form contracts around. Not all promises are contracts. And I think we need to look at what exactly is a contract. Of course, most people know that not all contracts need to be written down. You can just have a contract by, word of mouth. You can also have implied contracts where, that's the anyways, I'm going to get too deep into that one. We'll wait till next week where I actually film that video. But if you are interested in learning more about the introduction to contract law, subscribe. Subscribe to my channel, Lost in Law, and be notified when I upload new videos. Until next time, everyone, stay frosty.